Namaskar, welcome to online course on Indian Constitution offered by NALSAR University of Law and sponsored by Ministry of Law and Justice, Government of India. Today we are going to talk about the most important of all rights, the right to life and personal liberty. Now, why right to life and personal liberty is so important? Right to life and personal liberty is rightly said to be the heart of fundamental rights, because only when you are alive you can exercise other rights. If you are dead, you cannot exercise your right to speech. If you are dead, you cannot practice or propagate any religion. If you are dead, you don't need equality. So first of all, your life must be protected and guaranteed. Then only you can exercise other rights. Therefore, right to life and personal liberty is indeed the heart of fundamental rights. Now, this right is the primordial right which every human being anywhere in the world at all times ought to have. This is a natural right, basic right. It has been included in Universal Declaration of Human Rights and all other international covenants. And this is an inalienable right. You do not have a right to alienate your life or extinguish your life, or you take away your life. Now, right to life and personal liberty did find a reference in Magna Carta of 1215. Now, Magna Carta is said to be the first major document. Of course, Magna Carta largely guaranteed just the procedural rights. Nevertheless, we need to understand its importance. Magna Carta was basically giving rights to the barons, to the elite. And Magna Carta within no time was revoked by the Pope, because the then Pope said that King John's consent for Magna Carta was not a free consent. Still, one must concede that it was a milestone in the history of rights. And what did Magna Carta say? That no man shall be taken or imprisoned or diseased or outlawed or banished, or anyways destroyed, nor will the king pass upon him or commit him to prison unless by the judgment of his peers or the law of the land. It was a milestone. It is guaranteeing rule of law. It is guaranteeing rights of the arrested people. It is guaranteeing right not to be condemned without the due process of law. So what is the significance of Article 21, which in India, in our constitution, guarantees right to life and personal liberty? The state itself was brought into existence for protection of life and properties. Therefore, the very reason of creating a state, if you go by the social contract theory, was that people's lives are to be protected and their properties are to be protected. Article 21 is important because it protects the sanctity of human life. Life of each and every human being is precious. Article 21 embodies constitutional value of supreme importance in a democratic society. Human life is impossible without protection of life and personal liberty. Now, if you look at the drafting history of Article 21, originally it was Article 15 and it was debated in our Constituent Assembly on 6th and 13th of December 1948. There was a difference of opinion amongst the members because we had an option of including due process of law, which is an American doctrine. But many members in the Constituent Assembly felt due process doctrine is vague. It gives too much of powers to the judges. And therefore, to bring in certainty in our constitution, we opted for procedure established by law, which is inspired by the Japanese constitution. So the original Article 15 said, no person shall be deprived of his life or personal liberty except according to procedure established by law, nor shall any person be denied equality before the law or equal protection of laws within the territory of India. So right to equality and right to life and personal liberty were initially clubbed together. Subsequently, they were separated, and the second part of draft Article 15 finally became Article 14, and the first part became Article 21. And what does Article 21 say? No one shall be deprived of his life or personal liberty except according to the procedure established by law. We have discussed earlier that there are fundamental rights which we have guaranteed only to citizens. Article 19 rights. Here in 21, just like Article 14, right to equality, we are giving this right not only to our citizens, but even non-citizens. Even foreigners will have a right to life and personal liberty in India. What is the meaning of life? What is life? Life does not mean mere animal existence. If you are just allowed to survive and breathe, that is not life. Life extends to all those limbs and faculties by which life is enjoyed. In Maneka Gandhi versus Union of India, 1978 judgment of the Supreme Court, it was held, right to life is not confined to physical existence, but it includes right to life with human dignity. This is important. Right to life is not mere animal existence. It includes right to live with human dignity. And whatever is required for human dignity must be guaranteed. And then Maneka Gandhi further held that all that goes with it, namely the bare necessities of life, such as adequate nutrition, clothing and shelter over the head, and facilities for reading, writing, and expressing oneself in diverse forms, freely moving about, etc. They are all part of right to live with human dignity. And they are part of right to life and personal liberty. They are included within the expression life. Right under Article 21, as I already told you, is available only to natural citizens. In Article 14, we had discussed even companies are entitled to equality. But companies cannot have a life like human beings. So this is a right available to natural persons, and of course I told you, even non-citizens. In Olga Tellis versus Bombay Municipal Corporation, 1985 judgment of Supreme Court, it was held, right to life includes right to livelihood. You must have means of livelihood. Then only you can sustain life. Many a times we come across a situation where somebody is injured in an accident. He is taken to the private hospital. Unless you make a payment, the hospitals refuse to start treatment. In Paschim Banga Khet Mazdoor Samiti versus State of West Bengal, it was held by the Supreme Court that right to health is included within right to life and personal liberty, and right to emergency medical aid, even in private hospitals. So generally the addressee of rights is the state. Generally you can move in writ jurisdiction against state. But when it comes to right to health, the private medical colleges, hospitals, too must start your treatment immediately because it is part of your right to life. There are series of cases which were filed by MC Mehta. In one such case in 1987, Supreme Court held right to unpolluted environment is part of right to life. Of course, if air is not clean, if you have pollution all over, you can't get oxygen, then your life is either going to be shortened or may even come to an end. Right to shelter is included within right to life. In Unni Krishnan versus State of Andhra Pradesh, 1993 judgment of Supreme Court said right to education of children till 14 years of age is also included within right to life. Of course, this was one of the directive principles as well. But remember, higher education is not included. In the new education policy, which the government recently launched, there are possibilities of expanding this right to include even higher education. After this judgment, in 2002, 86th Amendment of the Constitution was made and Article 21A was inserted, which now guarantees as a fundamental right, as a part of right to life, free education for children between the ages of 6 to 14, and subsequently to implement this constitutional mandate, the right of children to free and compulsory education, RTE Act was passed in 2009. Right to reputation is included within right to life. We discussed it in the freedom of speech lecture. Defamation is a restriction on freedom of speech. Why it is a restriction? Because somebody else have a right to reputation. Similarly, right to free and speedy trial is implicit within Article 21. Why? Because justice delayed is justice denied. Of course, justice hurried is justice buried. But we have huge backlog of cases, and therefore we don't get speedy trial. Now, Supreme Court has said, getting a speedy trial, getting a fair trial are very much part of right to life and personal liberty. In M.H. Hoscott versus State of Maharashtra, Supreme Court said right to legal aid is also part of right to life. And in Ramdev versus Home Secretary, right to sound sleep. There was a protest going on in Ramlila Maidan, and then there was a police raid in the night. Supreme Court said right to sound sleep is very much part and parcel of right to life and personal liberty. Now, what is not included in right to life? There is a famous case of Supreme Court, P. Ratinam versus Union of India, where Supreme Court strangely held that right to life includes right to die. They also quoted my article at number of places in this judgment. Subsequently, this judgment was overruled, rightly overruled, in Gyan Kaur versus State of Punjab in 1996. So no one has a right to take his or her own life. Right to life does not include right to die. Right to vote is not included within Article 21. Right to property is not included within Article 21. Therefore, if somebody is displaced due to land acquisition, he cannot claim a right under Article 21. Right to revision of pay. All the time government employees keep asking that our salaries are low and they be revised. there is no right to revision of pay. There is no right to minimum support price, MSP, under Article 21 for the crops. Lot of debate is going on MSP. Now let us come to personal liberty. What is personal liberty? The expression liberty in American Constitution is given much wider meaning. And it is said, word liberty takes in all the freedoms. So liberty is not confined just to bodily restraints and extends to full range of activities which an individual is free to pursue. In our Article 21, this word liberty is preceded by another word. What is that word? Personal. Right to life and personal liberty. What Article 21 says? No one shall be deprived of his life or personal liberty. Now it is argued that since this word personal comes before liberty, does that mean that Indian guarantee of liberty is narrower compared to American right to liberty? In Khadak Singh versus state of UP, it was an interesting case. This man was involved in some dacoity. When he was released, the police will come in the night, make domiciliary visit, knock his door to find out whether Khadak Singh is in the house or not. And Khadak Singh challenged those rules of Code of Criminal Procedure, saying that they are violating my right to privacy, my right to liberty. And here Supreme Court said personal liberty is not confined just to a personal right not to be subjected to imprisonment, arrest, or other physical coercion in any manner that does not admit of legal justification. Rather, it includes all liberties of man not included in Article 19, Clause 1. You know, Article 19, Clause 1 is called Charter of Liberty. Number of rights are guaranteed there: freedom of speech, freedom to form association or unions, right to move freely throughout the territory of India, freedom of trade and occupation or business. Here Supreme Court said, whatever is not included in Article 19 is included in Article 21. Therefore, Article 19 talks of specific liberties and Article 21 talks of residue liberties. In Menaka Gandhi versus Union of India, Supreme Court said expression personal liberty is of widest amplitude and covers variety of rights. So what is included in personal liberty? We had a leading case in 2017 on right to privacy in Justice K.M. Puttuswamy versus Union of India. So Supreme Court said right to privacy is the part of constitutional core of human dignity. It is included within Article 21. The court said even silences of the Constitution are important. Therefore, even though right to privacy is not mentioned in Article 21, yet it is part of 21. Of course, like any other fundamental right, right to privacy is not an absolute right. But privacy is important because it is part of personal liberty and part of human dignity. Thus, even a woman of easy virtue is entitled to right to privacy. Telephone tapping will be a violation of right to privacy. But if somebody is HIV positive and the doctor discloses his status to the would-be wife, it will not be treated as violation of right to privacy. Right to travel abroad is part of personal liberty. Right of prisoner to write a book is part of personal liberty. He also has a right to socialize with family members. Handcuffing of the accused is permitted only in extraordinary situations. Passive euthanasia. I just told you right to die is not there. P. Ratinam judgment was wrong. Gyan Kaur occupies the field today. But if somebody is suffering from an incurable disease and is in vegetative state, then passive euthanasia can be opted for. Right to choose a spouse whom you want to marry is definitely included within right to personal liberty. Right to compensation. In Rudalsa versus State of Bihar, Supreme Court said, even while exercising writ jurisdiction for the violation of Article 21, compensation can be awarded. It was a remarkable new development because generally in writs orders are issued, but here compensation was given. Delay in execution. You have been given death sentence, but you have not yet been executed. So all the time you are having the horror of death. Supreme Court said, delay in execution is violative of right to life and personal liberty. Rajasthan High Court in one case said there should be public hanging. The matter went to the Supreme Court and Supreme Court said public hanging would be cruel punishment, inhuman punishment, and therefore it is violative of right to life. Right to electricity, right to pollution-free water are also included within Article 21 because you cannot enjoy your life if you do not get water and do not get electricity. What is the meaning of procedure established by law? We understood what is life, what is personal liberty. Now this is the third major expression in Article 21. Procedure established by law means procedure established by statute or prescribed by law. This procedure must be under valid law. We had discussed in the beginning of this lecture that deliberately the framers of the Constitution did not adopt due process doctrine for our right to life and personal liberty because it is a wider expression. Because court would then examine the justness and fairness of law and the certainty of law will be a casualty. So initially in A.K. Gopalan versus State of Madras, 1950 judgment of our Supreme Court said procedure established by law means nothing more than the procedure enacted by the state. So if a state has passed the law, that law takes away somebody's life or liberty, it is enough. Because Supreme Court said in Gopalan that procedure established by law does not include due process of law. But 28 years later, in Maneka Gandhi, Supreme Court said it is not enough that there is a law which has provided a procedure for deprivation of right to life or personal liberty, but that law must also be just, fair, reasonable, non-arbitrary, fanciful or oppressive. So merely if you have a law, your procedure established by law requirement is not met. If that law does not meet the requirement of due process. So in a way, due process has come back through activist judiciary. What is the relationship between Article 14, 19 and 21? Article 14 talks of right to equality. Article 19 talks of freedom of speech and expression. And Article 21 talks of right to life and personal liberty. In A.K. Gopalan's case, it was held that these articles are not interrelated, but they are exclusive. So Article 19 is not applicable to preventive detention. In Maneka Gandhi, in 1978, Supreme Court said they are interconnected and are to be read together. In recent privacy judgment also, Supreme Court said rights are not to be read in silos. So now we have to read 14, 19, 21. Since in Article 14 we talked of reasonableness, in 19 we talked of reasonableness, the requirement of reasonableness will come in 21 as well. So when can right to life and personal liberty be suspended? Every nation at times has to declare emergency. So Article 352 provides emergency can be declared when security of India is threatened by armed rebellion or war or external aggression. Earlier word internal disturbance was also there, on the basis of which in 1975 emergency was declared. Now that expression has been dropped. So Article 358 says, if there is such an emergency, all the rights under Article 19 get automatically suspended. In respect of other rights, other than Article 19 rights, Article 359 says that right to move to the court can be suspended during emergency through a presidential order. I just told you in 1975, Mrs. Indira Gandhi imposed national emergency and suspended Article 21 because right to move to the court was suspended. And when many people against illegal detentions moved to the court for habeas corpus, the Supreme Court in ADM Jabalpur versus Shiv Khan Shukla said that they can't do anything, because if right to move to the court is suspended or Article 21 is suspended, then the writ of habeas corpus cannot lie. Since right to life is sacred, the 44th Amendment of the Constitution brought in a major change by making Article 21 and Article 20, which talks of three rights: right against ex post facto laws. So you cannot have retrospective operation of criminal laws. Right against double jeopardy. For the same crime, you cannot be punished twice. And right against self-incrimination. This Article 20 and Article 21, right to life and personal liberty, after the 44th Amendment, are now non-derogable rights and they cannot be suspended even during emergency. Now let us come to the Aadhaar judgment. There has been quite a debate and a controversy about Aadhaar. Originally it was under an executive order. Subsequently in 2016, Aadhaar Act was passed. What is Aadhaar? Aadhaar is a verifiable 12-digit identification number which is issued by Unique Identification Authority of India. Remember, Aadhaar is not proof of citizenship. It is a proof of residence. Number of people went to the Supreme Court challenging constitutionality of the Aadhaar Act. The court initially referred the matter of privacy to the 9th judgment, to which we made a reference, and subsequently this matter came to be decided, constitutionality of the Aadhaar Act, and the Supreme Court upheld the Aadhaar Act, barring few provisions on disclosure of personal information, cognizance of offences, and the use of Aadhaar ecosystem by private corporations. Thus, while Aadhaar Act was upheld, Supreme Court quashed the circular of March 23, 2017, which mandated linking of mobile number with Aadhaar as unconstitutional because the court said it is not backed by any law. But the court clearly held Aadhaar does not violate right to privacy, of course, by the majority of 4-1. The court said architecture of Aadhaar as well as provisions of Aadhaar Act do not tend to create what is called a surveillance state. So what protection is available to those who are arrested or detained? Article 22 says no person is to be arrested without being informed as soon as may be of grounds for such arrest. Nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. We just discussed that personal liberty is beyond just bodily restraints. But here specifically Article 22 is addressing the questions of arrest. Now lawyering as a profession is mentioned in Article 22. Strangely, no other profession is mentioned in the Constitution of India. And then Article 22 says that anyone who is arrested is to be produced before the nearest magistrate within 24 hours. Now these rights, right to legal representation, right to be informed of grounds of arrest, right to be produced before a magistrate within 24 hours are not available to two categories of persons. One, enemy alien. If there is an alien, a foreigner who is at war with our country or whom our government has declared as the enemy, we will not give this protection to them. Similarly to those who are arrested under preventive detention laws like NSA, National Security Act, or Unlawful Activities Prevention Act, or in 1975 many people were arrested under MISA. Now these preventive detention laws are justified because prevention is better than cure. So the man has not yet committed the crime, but he is detained or arrested prior to the commission of the crime. We have seen in the context of HIV/AIDS that prevention is the only cure. And right now we are experiencing in COVID-19, the prevention is the cure, and therefore we must not go out without all the safety protocols and always keep our mask on. So no detention, Article 22 says, beyond 3 months, except on the recommendation of an advisory board consisting of members who are or have been or are qualified to be appointed as High Court judges. 44th Amendment in 1978 further tried to humanize preventive detention laws, but this amendment has not yet been notified. So what did we learn today? Right to life and personal liberty is the most precious and most important fundamental right. American Due Process Clause, which was not there originally in our Constitution, has now been judicially incorporated by the judgments of the court. In the next lecture, we will talk about another very important fundamental right, freedom of religion. Thank you very much. Dhanyavad.